member of the media. We don't permit the filming of jurors. I don't know if anybody told you of that. Okay, yeah, so you're not, right. Okay, thank you. You can be seated. Well, it looks like our lone gentleman is the foreperson. Is that right, Mr. Brunig?
Yes.
And has the jury reached a verdict?
Yes.
Which you provided to the bailiff then? We, the jury, find the defendant, Jason M. Huberty, guilty of violating Admin 2.07 sub 2 as charged in the citation. It is dated this 14th day of May 2013 by our foreperson, and there are no dissenting jurors. And at this time, I'm going to poll the jury. Ms. Borman, is this your verdict? Ms. Reese and Mr. Brunig. Ms. Cumente? Ms. Weiler, and Ms. Oberle. All right, well, thank you so much on behalf of the state of Wisconsin and the Dane County Circuit Court and the parties and attorneys. We appreciate your attention today on this beautiful spring day. I am available to answer any questions after I meet with the lawyers. If you would like to talk, if you don't, I totally understand that you might want to leave and enjoy the day. So thank you again so much for your service.
All rise for the jury.
You can be seated then. Mr. Gabrzyk.
I don't want to sound silly here. Do I move for judgment on the verdict? I believe I do. I think.
Yeah, I think that that's what you would do. This is a civil forfeiture, and what is the amount of the forfeiture?
I believe his maximum penalty is $500.
I think the deposit was $200.50. So.
Right, but the maximum penalty, I believe, is $500 when you read that section, the catch-all section.
Right, and so are you moving for that amount then to be assessed?
I am, Your Honor.
All right, Mr. Jamboys?
Well, Your Honor, first of all, the state would oppose the motion to enter judgment.
You, the defendant.
Here you go. There are 4 ways. Yeah. The defendant would oppose the motion to enter judgment on the verdict and would remove its motion to dismiss the case for failure to state a claim and for the other reasons cited previously on the record. And once the court rules on that issue, then if the court is still on the issue of the appropriate penalty, Your Honor, I would point out that my client is otherwise blameless. He has been cited a total of 21 times by the Capitol Police in the last 18 months or so. Of those 21 offenses, 21 citations, 20 of them have now been dismissed. This one has resulted in a guilty verdict by the jury, but the other 20 have been dismissed. When my client was approached by the police, he would repeatedly ask them, isn't it true that this is a public sidewalk? In the city of Madison, now, although the jury wasn't made aware of it, the court is aware that there is a specific ordinance that specifically allows trucking on the sidewalk. And so I think all of those factors would mitigate or would militate toward a penalty on the lowest side, potential side of the forfeiture amount. I don't know what, I don't think there is a minimum set forth, so it's anywhere, I guess, from $1 plus costs on up. And I would request that if the court is going to grant the motion to enter judgment on the verdict, that the court would issue a minimal fine or forfeiture.
Judge, may I be heard on the fine?
Yeah, you may.
Just in terms of the fine, Your Honor, I think the maximum is in order because Mr. Huberty admitted under oath that he was aware of the regulation, he disagreed with the regulation, but went ahead and did it in. I don't think that's an excuse in a situation like this, especially when he was warned by the Capitol Police. He didn't stop, he'd get a ticket. They didn't have to warn him. I mean, technically they didn't, but they did. And he still went ahead. And that's where I think is the real nub of this case, and it supports a significant sanction just from the standpoint that it is a knowing violation of law, even though the state didn't have to prove that.
All right, we've got a couple issues. One is what the amount should be. My understanding is I could do anything from $1 up to $500. And then the other issue is whether or not there are going to be any post-verdict motions. And I guess I'm still unclear what, if anything, you are intending to pursue, Mr. Jambois. I guess you have, 20 days to make any post-verdict motions? Is that right?
Yes, Your Honor. What I'll do is lick my wounds and then evaluate the case and make a decision after discussing it with my client.
All right. Well, I think that in light of the fact that Mr. Huberty has been cited 21 times and 20 of them have been dismissed, and in light of the fact that, in my view, the rule at issue here was clearly a close call in my mind about whether or not the ordinance applied to this activity, given Mr. Huberty's history, I think a $50 fine would be appropriate under the circumstances. So I am going to assess a $50 fine plus the court costs. I will
Judge,
give.
What about cleanup costs for the state? The state had to clean this up and it would like to submit.
Where is that provided in the code?
Can I take a look at that? To be honest with you,
All right, I'm going to give counsel 20 days. All right, well, I mean, there's something in 207, but there's nothing in the remedies section that talks about the forfeiture. I didn't see anything about cleanup costs. If you think there's a provision that permits it, you can ask for it. So I'm going to give both sides the 20 days to submit post-verdict motions. You can address the cleanup costs. You can figure out what, in terms of the statute, or not the statute, but the rule. I don't know if there are challenges to it and whether those challenges would be timely or not, or if you're going to even want to make them, but that's something you can address after you with your notes. Okay?
Thank you.
All right, sounds good. Thank you very much, and we are. Do you want your sidewalk chalked out?
Yes, please.
Did you enter a judgment, Your Honor?
Yes.
Okay.
I'm going to enter your judgment. Did they want to see?